Is that what you're saying?
Right, I sent it as an FYI
To the chairs of to you as the chair of ULURP and Fred and the community board. I didn't send it to the rest of the ULURP committee.
Okay.
I can forward it to them if you'd like.
Yes, and I also, I want you to be up, well, you'll talk later on the discussion around this because the judge seems to have an idea of how we should do stuff. So we'll talk about that later on. So we can move right along so we can have a discussion.
I just want to note that if you open up the chat, that people have the right to review that because you're going to have a discussion on it. And so anything that you're discussing has to be made public to all the participants who are currently present in the ULURP. So that means is that that email has to be given to everyone here who's in attendance. And so if you open up the chat, I'm sure there's a way in which people can then access it.
What are you talking about? The memo that I'm talking about that you sent to us? Is that what you're talking about?
Yes, I'm talking about the memo that came from the judge.
Okay, because, okay. Well, I don't know anything whether chat, you know, I can't open up any chat.
Well, can you do that, Ms. Hilton?
Hi, Ms. Boyd. It's my understanding that we're no longer using chats during the committee meetings.
So how are you going to be able to disseminate the information to the public?
We can post it on our website.
Well, can you do that now because it's supposed to be available?
I have to admin the meeting. I cannot post on the website and admin the meeting. No. I'm the only staff member here this evening.
Right, no, but that's not, we'll get into how we're gonna do things later. I was just wondering if everybody had a copy of that memo from the judge. That was all my concern was that, you know, if everybody had it, they could actually read what the judge said. And I think Nicola sent that out. She said she didn't send it to the whole committee, so the whole committee didn't have the opportunity to even look at what the judge said.
Well, what I could do to make it easier, because it appears as if you can't share it, I could read it.
Well, okay, well, when the time comes, we can read it. When we're gonna go into discussion about it, then you can read it. I don't have a problem with that.
Okay.
Okay, so next on the agenda, I done lost my agenda. I don't even know what's next now. Okay, let's see. Okay, Suki.
Hi.
How are you?
Good, good.
Good. So I think that you just want to give a brief update on what is it? 1218.
Yeah, I just wanted to follow up with Intro 2186 because it was in our agenda a couple of months back to bring something before the full board. There was a hearing on that at the City Council in March, and there were a lot of concerns and criticisms from the public as well as the Department of City Planning. It doesn't seem like they supported that. So I'm not really sure if it's moving forward. I think at one point we had passed a resolution saying that we were going to write some kind of letter or resolution in our committee. But I don't know if you guys feel that that's necessary or important now. It just doesn't seem to me like it's likely to move forward in this form if the Department of City Planning is not supporting it.
Okay, I thought you were just going to give because, you know, we sat in a meeting that I've never been in anything that long in my life.
Yeah, it was.
So it was. I mean, I've never sat through anything for 6 hours. I just thought that was just too long for anything.
Yeah, I did try to. I did send out some notes to the committee members by email. I don't know if you all got that. Just trying to summarize some of what was said by the council members and the members of the public. It was basically like a big gripe fest where people got to, you know, tell the Department of City Planning what they thought about how zoning was affecting their communities and the lack of planning for infrastructure budget, the lack of coordination with respect to budget issues, et cetera, et cetera. The fact that some communities were zoned properly and some were not. So it was, you know, it seemed like people had a lot of issues with the existing process. But a lot of people also really didn't feel like Intro 2186 was the way to fix it. So I don't know, a number of community boards had written letters to the city council and to the Department of City Planning to say that they didn't support Intro 2186. And I think we had voted to send some type of a letter as well. But as I said, I don't know if if that's something that you guys want to do. I don't know if it will be moving forward in its
Well,
current
I think
form.
we need to find out if, is it a standstill at this point? I think that would be the appropriate, because we did forward to the board, but I believe that they forwarded back to us to get more information. So you think you could do a follow-up?
Pat,
Yeah.
this is Richard. So city planning at the council hearing made it very clear they do not support this effort, right? I don't know if city planning is going to weigh in, but usually at council hearings, the affected agency speaks first, they get drilled, which lasted more than an hour. The council, the person that you had presenting to you, I believe you had council staff, Annie Levers. She was at CB8 on Thursday night. And so they're still doing the advocacy rounds within community boards that reach out to them. Board 8 decided they want to reach out to Tom and Gotti to get a counter view before Board 8 is going to consider whether they're going to weigh in or not. So this is still alive. Corey Johnson likely still would like to do this before he leaves, and we'll see how it plays out. It's possible the council may have more hearings. They may look to refine this bill. So it's still out there until it's not.
Okay, so we'll say it's pending. Okay,
Could we possibly see if we could, like,
stand something.
that's Esteban.
Oh, okay.
Could we possibly, I mean, if they're having Angadi come in and do like a counter proposal, would it make sense to see if we can join them on that? And ask questions and do all that sort of thing? Because otherwise, I don't see us really getting around to doing it. And it would probably have to be outside of our normal, schedule. But if even some committee members could make it to that meeting, then maybe we can help the board be able to weigh in if they want to.
Technically it's a public meeting, right? So boundaries of where you live shouldn't preclude you from the opportunity to sit in. How they open it up to non-board members. There are plenty of non-board members that participate in these committee meetings. So, if you want me to forward the link to the board office when I see it, that's fine. If you want the board office to reach out directly to Board 8, nothing's set up yet. Again, this is
Right.
pretty fresh because it was Thursday night.
Okay, can you make a commit? Can you make a commitment to forward it to the board office, and they will ensure that some of us get it? Because I don't know, time is short right now, so we're trying to move as quickly as we can. You want to say something, Fred? I see a hand up.
Yep, just very
And I'm
briefly.
happy to do that.
So I'm trying to follow the rules of order. So very briefly, and I think it's been said already, so this did go before the board before, and I think there was some additional information and background that we wanted to have vetted by the committee first. So it was referred back. The board office did make some subsequent inquiries with regards to try and get additional information in terms of from the council or from some kind of representation to give you what exactly it is that the speaker or, all the other sponsors are trying to actually convey with this. So it's possible we can have the conversation with the board office to renew that, as opposed to going somewhere else. I think you should have these people come and speak to you directly as you're the committee that's responsible for this. So we'll send another inquiry in terms of getting some kind of a resource to come and speak to the ULURP committee about this.
Right, and I think that if they come in, we don't have time. So my point is that if we, the entire board needs to know how they're going to vote. And they need to understand what's going on. So if it comes to us and now it's July, we don't even meet. So I was saying that if he has the information and we can get the full board to at least half of them to listen to whatever's going on, then they can make a decision, or we can make it.
Could I just,
Well, I just want to have
Okay,
the
or-
opportunity for the ULURP, for the whole committee, as opposed to you have to go, to the board. Yes, I mean, they're only the neighbors next door, but it should happen, that's something that should happen here in your forum. The city is responsible for doing that, so I want to make sure that you don't have to travel, so to speak.
Oh, no, I don't have a problem. I mean, they can come in and speak. My point was timing.
Oh, yeah, absolutely.
I mean, we have two things going on right now. I mean, at least one important thing going on right now. And so I just wanted to understand like how we're gonna do all of this within a month, Because again, the committee members and especially the board who has to vote on it, they have to know what they're voting on. Because like I sat through 6 hours of it, and I saw Alicia up there too. You came in like on the second day or something, or you was like towards the end. But I saw a number of people speaking, giving a testimony about what was going on. So just wanted to bring it up that we didn't forget about it. I know you shot it back to us, if I'm not mistaken. So.
and if we do that, I don't know if there's going to be time for it, but it seemed like after, at least at CB8, it seemed like the committee members really wanted to get the sort of opposing view right away. So that may be something that you want to schedule together. If you want to have somebody else come in and talk about the cons, since it's going to be very, very pro when the city comes in to do it. So,
Well, I'm going to leave that up. I'm going to leave that up to the committee. And I guess you keep it in your head, or someone we can take a motion to what we're going to do, because
Okay.
I don't want to. It's not my decision by itself,
Right.
So I want to just keep that in mind, because I know I'm going to forget as it gets towards the end. So give it some thought as we're moving on. Okay. Now I know that we had some. Mia, did we do any update on the materials that was requested by Community Board 9 for 960 project? I know there was some additional materials that we were going to follow up on to see if the developers was going to submit to us. Or,
Yes, we received no further correspondence with regard to outstanding materials.
okay, and when was our last dated correspondence to them?
I would have to go in and pull the email,
Okay,
but unresponsive to any request for documentation.
can we send it out again then with a new
Yes.
date? So let's do that.
Will do.
Yes.
May I just make a suggestion? Because
Yeah.
obviously the judge is going to be listening to CB9's reaction and paying attention to what it is that you want. May I suggest that you ask the court that the developers give you the draft restrictive declaration, and that be something that they have to give you ASAP, because they have it. They promised it at the last time that they were here in front of us. The gentleman said that he was going to give it to us. He did not. So you could ask the court. You could put a motion in on the floor to ask the court to ask them to give us the restrictive declaration, and I will convey that wish to the judge tomorrow at 2 o'clock during our hearing. And that might actually be more effective.
Is that all we asked for?
No, we asked for quite a number of other things.
No, it was two things that we had asked for.
The draft restrictive declaration was one, because it contains so much information about the project, including exactly the design of the building, the number of residential units, the affordable categories.
Right, but what was the second one? It was two things that I was looking for. I can't find it at this present time, but it was two things that we have requested.
Oh, you wanted more details about the affordable categories underneath the MIH program, the amount of apartments, the sizes of those apartments, and the target population
Well, you know what?
and where those
I-
apartments were going to be
You know what? We'll
located.
look it up. We will go back to whatever was requested in writing from the community board and see if we can send it out again.
If we're reaching out to the developer for documentation, would it be possible to request any documentation related to the partnership between the developer and the local development corporation of Crown Heights, which we didn't know about until today?
Well, I don't want to go that far. As a matter of fact, it wasn't the developers. You know what it was? Now it's just saying that it had something to do with the union. Y'all were, somebody was requesting something.
Oh, yes, you're right.
Union.
Suki brought
Right,
it up
that's
at
what
a
it was.
previous meeting, the financial agreement and corresponding docs with local 32 BJ.
Right, that's what it was. So I could
Yeah,
think
but
of-
I don't know if that's a part of the ULURP process.
No, it was just requested by a committee member who was interested.
Oh, okay, so, all right, so we don't have to, they don't have to.
The thing with the local development corporation is that it will actually affect what gets built in terms of the affordable housing portion. So it is really crucial that we be able to look at it and see what that partnership entails. Otherwise, we're not really going to have a clue as to who's paying for what and how they're, I just think it's important that we look at it.
Okay,
The only thing I would want to say about that is, I'm not sure if that's in the scope of a document that was filed with DCP with regards to this ULURP application. So I'm not sure. I mean, you can ask for it, whether you'll get it or you're required to get it, they're required to give it is a different conversation. So I just want to put that out.
Yeah, of course.
And make that request.
correct.
Yeah.
Right.
They could be nice and give it to us.
Well, if they're not even given the required documents that are part of the application, and they've made these promises
Got
several times to do it.
If they're not required to do it, then, we're gonna just, whatever they're required to give us, that's basically what we're gonna, you can ask anything extra, but like she said, they don't have to do it. Okay, let's go into.
Can I just say quickly, the other piece of information that I'm surprised is still missing is a recorded sale. If you look in the city records on Acris, no sale of that piece of land, 960 Franklin, has been recorded. There's only a memorandum of contract. Has this piece of land actually sold?
It likely hasn't. I mean, if it's anything like the development across the street at 931 Carroll, the sale was dependent on the ULURP application being processed, and it's a different price for the land if it's regular land or if it's upzoned land. So my guess is that they haven't actually completed that sale.
So I think that's very important for us all to keep in mind.
Okay, what you need to also keep in mind, which is gonna bring me into the next subject, you have to remember that we were in fact certified, okay? So you have to keep that in mind. You can't just erase that.
Well, I think
whereas the Kiwanis, I'm not even sure at the time that they put in their court papers that they were even certified at that time.
yes, they were not certified. However, the judge lifted the TRO, they became certified, and then the judge put the TRO back on to stop the ULURP clock.
Okay.
So now they are certified, but the clock has been stopped, just like in our case. But I do want to go back to.
Well, let me go into.
I just want to make
under new business or is that-
no, under old business.
Oh,
just
okay.
why the restricted declaration is important, because the law requires that the property owner, in order to build an industrial manufacturing development project, he has to own all of the property lots or be in contract with all the property lots. And so it was not just 960 that is a part of this rezoning, it's all of the other additional lots that are around it. So it's like 5 properties or 4 properties that are involved. And again, we have not seen any sale of these properties or any agreement to buy these properties, but they have to be a part of one ownership in order for the manufacturing industrial zone to be done. That's why the restrictive declaration is so important, because it actually shows part of this development project. And it's not just 960 Franklin Avenue.
Okay, thank you. Okay, so now we're gonna move into the new business. And up for discussion, committee members. The discussion for the virtual and hybrid Zoom and in-person public hearing. I think, okay, who wants to be able to speak here? Committee members, don't all jump up at one time. Esteban, you said the memo out, so why don't you talk first? Because you
Well,
said.
you know, I'm trying to get I'm trying to read this, these different orders from the judge and would like to have
So
had a little bit more time to do that.
Yeah, let's read out what you wrote to, since it's not, read out what you wrote to everybody, just now, really.
Yeah. So first of all, can I just ask when we received this communication from the developer? Was it today?
Yes,
Yes.
Okay.
How you know?
because I'm one of the petitioners on the case, and they cannot send ex parte communications without notifying me.
Oh, okay, got it. All right.
I want to note that this is not the first time that we've gotten the day of a meeting stuff that could have been, you know, anytime sooner. I think that it's not really a good practice to allow them to do that, but since it's done, I'm concerned that that we would put this in the hands of a nonprofit that has actually like gone against the wishes of this community board on occasion before, and that we had no, you know, that we have no idea how they're going to like present this. I mean, we're basically putting, my counter sort of was to say, like, you wouldn't let MTOP or CHTU do a CB9 hearing and expect it to be non-biased. Like, these are people that are going to have like a vested interest in this project being approved. Also, that you know, no negativity meant towards the pastor of First Baptist, but he has come out very publicly in favor of the original 40-story whatever development at 960 Franklin last year. So, you know, I just don't really have a whole lot of confidence that we're going to have like an actual, like a real unbiased, neutral hearing where we can all, you know, state our claim and say what we want to say. I just don't think that it's, you know, I just don't think you can put it in the hands of the people that are, you know, going to make money off of it, basically. So that was the gist of my email, and I wanted that to. I think what they're asking is for CB9 to acquiesce to this request and tell the court that it's okay. And I don't think that it's okay, and I don't know how the other committee members feel, but I feel like if it's not, it may be something we should vote on, and then that can go to the full board, and they can decide if, you know, as a full board, if that's something that we should be able to, if we should be doing that or not. And I know that I realize that means that we would probably have to take on some of the responsibility for putting together something of that nature, but I would much prefer to do that and have us, you know, volunteer our time to do that if need be. I'd rather have something where people really feel confident that they're getting a non-biased and, like, you know, everything's like, you know, everything's face front and, like, you know, just, it's just a bad look. I think it's just a bad look, honestly. I think the optics of it are really not even necessarily suspect, but, you know, the way that he has done this, and, you know, with even like the language of like making it seem like we're sort of like complicating the situation, and maybe we are, you know, but I also don't understand can somebody explain to me the issue with having it outside as opposed to indoors, and why the city was so adamant to have an indoor meeting during COVID?
Well, I wanted you to really read your memo, and then I was going to have Nicola read what she sent to us that was from the judge.
I can read it if you'd like.
Yeah, and then the reason is because right now I'm not really into what people's personal opinions is. I'm trying to get a picture of how we can make all of this work.
Yeah,
so I think you gave a good overview, but I think you wrote something a little bit more than that. Am I correct?
Let me just read it. Yeah, I'm happy to read it.
Yeah, read it.
All right. So I said greetings. I would like to state my objection to the use of First Baptist Church for the official hearings for 960 Franklin, as well as to allowing Local Development Corporation of Crown Heights to run the logistics for the hearing. Reverend Moore wrote an op-ed last year for the Daily News voicing strong support for the project in its original incarnation. And I put the link there. I'm not confident that either First Baptist Church or Local Development Corporation of Crown Heights will allow a public hearing to proceed in an unbiased and neutral manner. Would we allow MTOP or CHCU to host an official public hearing on behalf of CB9? The optics of allowing them to do this, which is brought in to generate community support at the Bedford Union Armory as well, is bad for CB9 and this committee and will call into question our ability to deliberate on this topic without bias or prejudice. Therefore, I am requesting that the Land Use Committee hold a vote at tonight's meeting to either approve or reject this plan for a hearing, and that our vote be communicated to the appropriate parties, including the court if necessary. I would also like to know the nature of the partnership between First Baptist Church, Local Development Corporation of Crown Heights, and the developer, as it is imperative that there be transparency regarding all aspects of this project. It is exceedingly rare for a partnership to be initiated between a developer and a local development corporation for a private developer-driven application. That the local development corporation happens to be tied to a religious institution only demands more clarity regarding the nature of the partnership. It is almost guaranteed that we will face lawsuits of all sorts if we proceed with the developer's request here. I urge my fellow committee members to join me in demanding a vote on the matter and to reject the offer of assistance from the entity that helped push through the Bedford Union Armory project against the unanimous vote of this committee and Community Board 9 as a whole. So yeah, that's it.
Okay, thank you. Nicola, can you read what was sent to us from the judge that you sent to? Is she there?
I'm here. I'm trying to pull it up.
Okay. Yeah, can you just read? It was some information that you sent, and I think you sent it to the board. I'd like you to read that so that we can get a perspective on how or what the judge was saying in that particular.
Okay. Okay. So the judge sent this out to Alicia Boyd and the other plaintiffs. As the parties may know,
when is it dated though? It's dated
Monday, May 10th.
Okay.
Is when it was distributed. It was sent out.
Okay.
As the parties may know, on Friday, May 7th, I issued a lengthy order concerning the TRO in the Gowanus case. I would like to lift the order in the Boyd case upon receipt of a detailed plan as to how the developer respondents plan to ensure that a hybrid Zoom place of public assembly, ULURP hearing will be held. I will not lift the TRO based on a vague promise in the order that developer respondent will work with the city or CB9 to create a detailed plan. The updated CB9 hearing protocols on in-person support are too vague and hardly address the public space aspect of the ULURP hearing. Petitioner Boyd submitted a plan which micromanages what should happen. Since the developer respondents have graciously agreed to work with a not-for-profit to publicize this event, I would appreciate their sending me a counter-proposal and how this Zoom public assembly hearing should be held. I'm reworking the order, but need a detailed plan with some kind of binding statement from CB9 that it will in fact cooperate with respondent developers who will consult with petitioners, given the city's adamant stand during the last hearing that it opposes any gathering outdoors to facilitate the participation in a Zoom hearing. The sooner you send me a counter proposal on how to accomplish the public hearing and the site where this will be held, the sooner I will lift the TRO. Your cooperation is appreciated.
Okay. Thank you. And then I believe something was sent in from, was it sent in? Okay. I think something was sent in from the developers. Was it, I think it was today?
Correct.
There was so much stuff coming in at one time until.
Yeah, Mia forwarded something around 4, I believe.
It was, yes, that's what I'm looking
from William
now.
Wallace. And that's what Esteban replied to.
Right, but I would want that to also
be read.
But
I can read it.
Find it. Huh?
If you look at the Esteban's email, it will be right below. It's
okay,
part of the same stream.
It'll be right below. Well, since you're looking at it and I can't find it, can you read it?
I can read it. You
Esteban,
want to read it, Nick? Yeah, I got it. I got it. Dear CB9.
Reading it.
Esteban's reading it.
Oh, okay.
Dear CB9, I once again want to thank you for your continued professionalism and civic commitment. This has become quite an ordeal, so thank you. By way of clarification regarding the protocols mandated by the court to lift the TRO in place at 960 Franklin Avenue, I want to provide some specifics and seek your assistance in certain matters. Although we had hoped to utilize Medgar Evers as the venue for the public hearing, because of COVID-19 protective measures, Medgar Evers public assembly places are not available. Instead, we will be hosting the in-person portion of the hybrid Zoom in-person meeting at First Baptist Church, located, as you know, LOL, at 450 Eastern Parkway, Brooklyn, New York, 11225. Reverend Moore has been gracious enough to welcome us into his sanctuary for the meeting. We will be retaining as our not-for-profit partner, the Local Development Corporation of Crown Heights, located 252 Kingston Avenue, Brooklyn, New York, 11213. In their capacity as facilitators of the hearing and in complete coordination and direction with and by CB9, Local Development Corporation of Crown Heights will provide all necessary personnel, audiovisual capacity, and assistance where needed. COVID-19 protections, including but not limited to masks, temperature checks, social distancing seating, hand sanitizer, etc., distribution of flyers and other suggested methods of community outreach, distribution and collection of all pre-registration forms, medical forms, and any other forms of assistance needed by CB9. It is my understanding that the Department of City Planning has or will prepare medical forms and pre-registration forms for the scheduled hearing in Gowanus. We would greatly appreciate any assistance CB9 could provide in obtaining these forms from the Department of City Planning, so we have uniform compliance under these newly enunciated ULURP proceedings. Additionally, although we cannot set a date certain until the court lifts the TRO, we anticipate having the meeting no later than sometime in the second week in June, so as to allow a full CB9 vote before the commencement of your well-deserved summer recess later next month. We must, of course, coordinate with you police safety measures and address other specific procedural rules for the public hearing, such as commencement time and duration of the meeting, time allotment for speakers, etc., and are looking forward to our collaboration in allowing our community to be heard. Because the court is seeking, as evidenced by the previous correspondence I sent, some acknowledgement from CB9 that you are committed to moving this process forward with an agreed upon protocol, I am asking for and would greatly appreciate, after all due deliberation and discussion, a reply email stating exactly that. Thank you again, William Wallace IV, Continuum Company.
Okay, thank you. Anything else that the committee wants to speak about before I kind of open it up for discussion?
This is Nicola. I'm just curious as to
What CB9 has heard from the developers. I see this email came through, but what is corporate counsel, what information have they shared with the community board about the direction from the judge? Have they had any conversations with the developer prior to this email that was sent out today, stating that they're taking the lead on finding a location? I'm just curious as to what interaction and communications, how in the loop has Fred been kept in terms of what's been going on the last few weeks?
Sure, I'll speak to that. With regards to the emails, I think one of the things that you're seeing is that we kind of see them after the fact as well, as we are not a party to this lawsuit. We see them after the fact. In terms of the discussions we've had with them, the board is at liberty to decide how we want to proceed. With regards to the developer has provided a proposal for a protocol for this. It is, right now it's in ULURP committee's hands in terms of if you are satisfied with this proposal, absolutely you can make your recommendation. If you think that there are things that it's missing or it needs to be tweaked, that is absolutely what we're looking for from the ULURP committee in terms of those recommendations. If you don't see a path forward in terms of if it's insufficient or if there are other things that are in the way in terms of that are going to stop this from being the process that we want it to be, that is a recommendation that is also in line that the ULURP committee can make as well. So that's basically where it is with regards to that. In terms of the communications, I think that originally we were waiting for outreach from the developer, and the outreach came in the form of the proposals that you've seen before with regards to the recommended protocols with whatever they posted with regards to that. So those have been forwarded to the, shared with the chair, these being shared with the committee. And at this time, this is where the committee has an opportunity to weigh in terms of that. But I haven't had much more information than what you see in front.
Okay, and again, it was a lot of material to read.
I do have a question. Did anyone reach out to Mega Evans from CB9? Because I know the developers are making claims about Mega Evans not being available, but I'm wondering, did anybody from CB9, the CB9 ever reach out to Mega Evans themselves and ask? Because they have an atrium that's outdoors. They have an outdoor atrium that they could use that is made for that. It's an amphitheater, I'm sorry, an outdoor amphitheater. And which would, be a lot safer, and it would be a much more neutral place. It would not be indoors, it could be outdoors. And let's just be clear about the city's position. So I just want to make a note of it. The city states that they are not going to support this in-person hearing, period, whether it's indoors or outdoors. They said that if the judge directs them to support this hearing, that they will file a motion in the second department demanding that it not occur. So the city's position is not supporting this, period, whether it's outdoor or indoor. However, it is supporting the Gowanus outdoor in-person hearing. So again, I'm asking, did anybody reach out to Mega Evans from CB9 and say, I know you got this great amphitheater outside, is that available to us?
And I'll say that I know that we had discussed it. It was an idea that was floated with regards to Mega Rivers. Mia, if you can confirm if we ever had a conversation with them. I know at another point we were reaching out to the Department of Education, and that was discussed as well with regards to reaching out to them to see what their policy was. As of at least 2 or 3 months ago, I think we reached out, and DOE was saying that at that time they weren't considering any outside groups coming in for that. We had discussed sending that communication. I'm not sure if it went out already, or if kind of all the actions you're seeing in terms of the proposal coming in kind of said, okay, well, listen, we're already making those inquiries, so we might not have done that. But Mia, is there anything you can add to that, or can you confirm any of that?
Yeah, it is my understanding, Beverly Davis, who is the director of events at Medgar Evers College, that they were not interested in hosting in any capacity or exposing their staff to outside visitors, making their space available, because now they then become subject to providing staff additional cleaning, and that's something that they were not ready to take on.
So it was more about money than it was about health? Is that?
No, this is actually the second time. Actually, another community organization had come to us asking assistance and requesting Medgar Evers to allow them to use that same outdoor space. Mm-hmm. And that was when I believe the COVID testing was happening in the parking lot, in the FAR parking lot. And they, even though it was an outdoor space, they said that they did not want the liability of hosting people in any sort of capacity, or making the staff responsible when interfacing with people. And
that's probably consistent with a lot of what we see, because typically we'd be going into graduation season and they'd be using that. So it's really probably an example of that, where they're just not ready at this stage to bring in outside groups and everything that goes along with that.
Yeah.
Well, has anybody looked at any more neutral churches outside of Baptist Church? Because Baptist Church is not a very neutral church. Like you said, it's the only church in the community that actually wrote support of this development project, an op-ed. I mean, we got tons of churches all over our community. Has anybody reached out to any of the other churches to find out if they'll be willing to host this, so that it's a more neutral place?
Well, let me put it this way. Okay, you can just. I just want to say this, that, and this is where some clarity. First of all, according to what the judge is saying, in conjunction with us, that developers will be picking the location, not Community Board 9.
No, that's not. No. It's up for grabs. They put a proposal in. Trust me, Pat. I'm there in the negotiation room with the judge. It's not necessarily true. If you
But
guys,
what I do want to say is this, from the conversations, my understanding is the developer has really,
if you guys,
kind of been motivated with regards to trying to find the locations, which is the reason why I think in the previous protocol we received, they floated Mega Rivers. But I think we should note that it wasn't a guarantee. They said their recommendation was Mega Rivers. And I think that's part of the reason why we're seeing, after the inquiry, they said Mega Rivers is probably not doing it. And that's why they're at the stage where they contacted First Baptist. But in terms of some of those communications, this has been fast moving. So some of these are not even inquiries we've made, but this is something that I think the developers taking the initiative in terms of doing the outreach, because they're trying to see if it can come to something where CB9 can come to an agreement and say, yes, this is a plan we're comfortable with.
so again, has anybody reached out to any other, because again, First Baptist is not a neutral space. It's, you know, it's not a church that's neutral. They have supported development projects in our community and have, you know, that we went against, and they're now doing it again. So there are a lot of churches in our community that might be willing to host this. And will the community board consider some alternative places?
Well, just based on what I'm reading, and correct me if I'm wrong, the developers was supposed to find the location. And this is why I really have problems with everybody talking kind of around Community Board 9, and we get it secondhand as to what's going on, and then we should make a plan. I don't think that we'll have a problem making a plan. We just need to know, what are we planning?
Well, I think the judge is very clear. You guys have to agree to a plan. So the developers can say this is a plan, but if you don't agree to it and you want to substitute their plan for your own plan, or give yourself some leeway to be able to create a plan, the judge will be amenable to that, because she understands that the developer cannot conduct this hearing. You cannot conduct a hearing in which you're looking for approval of a ULURP. This has to be conducted with CB9. CB9 has to be the one conducting the hearing. So the developers have proposed right now a church and proposed a nonprofit, both that they're highly connected with and very much in bed with. CB9 can, you know, offer an alternative and maybe give you a couple of weeks to do that, you know, so that you can do your own outreach to the community. You can look at nonprofits that might be willing to assist. That's not connected to developers. That's not a development.
Well, let me just, and this is just my opinion, because, you know, you'll take a vote at the end. This is just my opinion. When you, okay, first of all, when they're reaching out, they're going to have their own people that they're going to pay to do these, to do the site monitoring. The problem I have is that I don't believe that Community Board 9 should get involved with who they hire, because it puts us in bed with them, and I don't really want to be there. All I'm saying is that they are picking the location, but they're also going to have non-for-profit people. It looks like right now, and I don't understand why we can't have the same thing in terms of the DCP. Why won't they assist us the same way that they are going to assist Kiwanis? I don't get that. So we have to rely on ourselves and the developer. And I don't see any input from them at all to support us in anything. But if you will read that court, I believe it's the Supreme Court, and it talks about that whole case with the Kiwanis and what the judge says about the whole scenario. And you need to read that if you have it, because I like a lot of things that's set up in there, and we can modify it to fit us. But for us to say we're gonna pick the place, we can't pick the place and hire people too, because that's definitely a conflict. There's no way. That's a conflict. So
Pat, I've had my hand up for a while.
Yeah, I understand, but we're doing committee right now. Just hold on a second. Mhm.
Could I comment on what you just said?
Yes.
So if we were doing this hearing and COVID hadn't happened and everything was normal, we
Uh-huh.
would be running this hearing. It would be in whatever auditorium we would normally pick, and it would be us doing it, right? Because it's a hearing for the community. So I don't think that it is a conflict of interest for us to say we would rather have it in this place or that place, or to say we would rather it not be Local Development Corporation of Crown Heights, who has traditionally been brought on as a nonprofit partner whenever they're trying to dress up a development in order for the community board to approve it, which is what happened with the Bedford Union Armory. I was on the committee when that happened too. So, and also, not to say that it's the pastor of First Baptist is graciously allowing us to come in when the pastor has literally put out a public proclamation that they're in favor of this project. And so, like, I don't think I don't think there's anything wrong with us saying we want something that's neutral, or we want it in a church that's different, or maybe have somebody else facilitate it. Why don't you let MTOP facilitate it? You know what I mean? Like, let somebody that is, like, make it even somehow, because otherwise I don't see how this is going to be
But
fair.
do you understand how the issue is here? In other words, for Community Board 9 to come in and say, oh, okay, we're going to pick the staff, but however the developer is paying for their salaries, we don't want to be in that position.
This is our hearing. This is the only opportunity that we as
I
a
get what you're
community have.
saying, but you don't
You know what
have
I mean?
staff. And Kiwanis have staff because they have the Department of City Planning assisting them. We don't have that.
I
That's
agree
my
that we should
point.
demand that we get the staffing and the resources to do it ourselves.
Who you
But
gonna
it should be
demand
coming
it
from us,
from?
from the Department of City Planning.
Well, what, just so I
Hold
can
on,
just,
Lisa, hold on. So you saying demand what?
I'm
You
saying
can-
demand whatever Gowanus is getting that we should be getting too.
Well,
You-
that's my point.
you could demand, and the developers at the beginning of the hearing stated that they would be willing to provide resources to facilitate this meeting, this hearing. So you could demand that the developers provide the financial support to conduct the hearing, but that you control the space and the staffing to ensure that there's neutrality at the hearing. So you could demand this. You can put this to the court, and then the developer.
Okay, this
Because either way, the developers have to spend money, right? They're willing to spend money, but it appears that they only want to spend money with partnerships that they are already in bed with, that are already supporting their development project, and this is what causes the conflict.
I'm just putting a position here in terms of the community board. And all I'm saying to you is this, that the minute that the community board gets into who is going to be hired, where the place is going to be, and now a developer is going to pay for it, then now it's a conflict.
It's not a conflict, Pat, because it's CB9 hearing.
It's
That's
our
your
job to do that.
That's right.
It's not your job to do that. It's not your job to hire people.
Think about, he's talking about setting the amount of time that each community member is going to get to speak. Like, this is the hearing about their project. Like, we should not be allowing them to do that. Like, that's a much bigger conflict of interest than them providing staff. They're getting to dictate all of the terms of, like, the only time that the community gets to speak.
No, they don't. No, that's not what it said. The plan is supposed to be worked out between the community board and the developer in conjunction with the Department of in conjunction with Community Board 9. So you see, 3 people will be deciding on what the plan is. And I don't think that we can exclude, I don't think we could exclude city planning, but however, I'm not sure whether they're a part or not a part of what's going on.
They say
If I can offer, I think at this point, what might be good for the committee to do is, because if that's the 1 or 2 things that blocks this plan, but otherwise you're good with the plan, those are the negotiables. In other words, you can get them to the table and say, we have an issue with this, let's discuss that and see what you can do to resolve that. But ultimately, what I'm looking for from the committee, and this is going to be the question for the board, is what the proposal is in terms of items 1 through 9, something that the committee and the board are comfortable with in terms of this is something that we can have the process, we can have the outdoor in terms of the indoor, outdoor, whatever the space is. There's a sure that all the appropriate controls can be placed, where we're sure that everybody can speak, and have an end result where it's like the public is informed and the board has all the information it needs in terms of making a proper vote. But let me add this as well, understanding that we are now at May 11th, the board concludes on June 23rd. So understanding all those things, but also putting it in the framework of, can we pull it off? So while there's a loose framework, some of the stuff is workable. You also have to get into the nuts and bolts a little bit of, okay, if we're going to do this hearing, can we do it by that second week of June that they're talking about? Can we have the input and can we have the feedback that we want to have? Can we schedule it for a vote in June? And I'll throw it out already. June is going to be a tough month because we already have our scheduled elections. So June is going to be a tough one. So before this committee, I'm asking, requesting that you be able to review that. If this is something that can fly, okay, give us the game plan in terms of what you think is workable. If there are really a lot of challenges that make this difficult, then that's fine. We can hear that and we can look at that, and then the board can make whatever options, make any decisions based on that, saying, listen, it's very possible it might be too little too late. We just don't have the time, we don't have the bandwidth, and even with extra resources, we might not be able to pull this off in a manner that's acceptable to the board and the community. But I just say that just in terms of looking at the proposal to figure out what works. If it's small stuff you guys just need to tweak a little bit, okay, do that. If it's really, really a lot of problems that we're probably not gonna be able to do, that's probably that's a conversation as well. I'm sorry.
I guess it depends on what and on how big that objection is, then, like the location and who's facilitating, because they chose a nonprofit partner, fine, but any church that says that we can be there shouldn't be any different than First Baptist, for that matter. And I'm certainly not going into First Baptist myself because I have personal issues with them. So but that's just me. But in terms of facilitation, that I feel like could be. I mean, there's all sorts of other organizations that could potentially facilitate that with the same level of whatever it is that they're planning on doing there. This seems really suspect because of the fact that they brought on a notoriously pro-development like corporation and First Baptist, which had already said that they were in favor of this plan. So like everything from how much time is spent to I mean, they're talking about hiring people essentially to hand out flyers. Where are they handing out flyers? Who are they bringing into this meeting? Like, these are all questions that normally the community board would be in charge of dealing with, to make sure that we get all the people in that surrounding area, all the tenants in that area. There's a lot of people that I don't think that First Baptist and Local Development Corporation know how to reach. So I think there are serious contradictions here that we really should. I mean, I don't know what else happens either, though. Like, if we don't have this hearing, what happens? If we don't have this hearing before the end of June.
Okay, but
Part of
that's
the
not
protocol
how.
would be also, I'm sorry, just real quick point out. Part of the protocol will be this. Advertising might not be what you lead to them. So in other words, get the space, get the people, have people there ready to wipe down things. We'll handle everything else. So that might be it. But as I say that, you also have to consider what resources we do have. We have 3 staff members. Maybe there's other things that you consider. Well, listen, in addition to that, you get some other staff to do other things. But those are the things you ask for. This is the negotiation. That's what you want to consider and ask for. Right. So that is the question.
I think calling it the facilitation, which essentially means the running of the meeting, I think that's problematic. And then again, a neutral location would not be like Alicia said. There's Full Gospel Tabernacle, which has enough space for this sort of a meeting as well, and is traditionally not involved in development stuff. So it would be a neutral place to do that. I think there's other ways to do this, but getting it, the day of our meeting and not really having time to do it has really put us in a difficult position. And I want to point out that these are things that could have been done sooner. Like, I know that there's a court case and all of this stuff, but there seems to be a pattern of trying to fit this into put us into a corner on these kinds of decisions. And I don't really like that precedent at all. I think it's really disheartening, and it just doesn't allow us to do the work that we're here to do. So
Okay, then let's speak on first of all, the plan, and again, I'm going to repeat this. The plan has to be between community board non-staff, our committee, and the developers. So right now you don't have a plan. You got what people are suggesting you should do. It's not a plan. A plan is when you outline everything, what's going to happen, how many days, da 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 da. That's a plan. So right now we don't have a plan. We got a lot of different pieces going on. And if the judge is, if they're saying that they're going to pay for the space and everything, and this is what the judge is looking at, so who are we to say where the space is supposed to be?
Well,
However, let me finish. They don't run the meeting. We do. When you talk about a public hearing, they're not going to be running the meeting. It
But-
would be Community Board 9 running the meeting and chairing the meeting.
They're talking
They're
as though
only
they're running a
one-
meeting.
Yeah.
That includes finding the space.
Space and confirming what space we want to use and advertising the meeting and facilitating the meeting, yes. If they're willing to give us money to make sure that the meeting can happen,
No,
fine, we'll take money.
We can't take money. What I'm saying is we can't take money from them.
yes, yes,
To
you
pay
can.
for the
You can.
space, yes, you can.
So we can't take the money.
Yes, you can, but the community, they can pay, if you decide, for example, that you want to go
Not
into
me,
another,
we.
if the community board decided that they wanted to go to another church and the church had a fee, then the developer could pay that fee. So that it doesn't necessarily, you don't get the money, the church gets the money, the developer pays the money for the fee. And I think what's really important to understand is that think about this developer, Pat. Think about how they have treated us. Think about all the things that we've been asking for them that they have not been responsive to. And now they want something from us. And so now you have some power here because they're asking something of you. They have to get Community Board 9's agreement to this hearing. And so you need to weigh that power. Why would we allow a corporation who has been supporting development projects in our community that went against our wishes to run another meeting, our meeting?
They're not gonna run our meeting. That's what I'm trying to tell
But
you.
that's not what Pat, trust me, I read the document. If you could trust me a little bit, I read the document. They are running the meeting. They said that they are going to be facilitating. They used that word, facilitating. That means that they're running the meeting. They're deciding this, they're deciding that, they're deciding everything. And all they need is for you to do is come like, some blind person and say, okay, yes, I'll just agree with it. And they themselves have been so disingenuous. Where is the draft restrictive declaration? Why don't they give that to us? We've been asking for that for months and
I
they
know,
have
but
not.
let's just stay here on the subject.
But
What I'm saying is this. If we're talking about a plan, then the plan would have to be, like I'm gonna name it again, it has to be between the Community Board 9, the developer, and the committee. That's a plan. We can't say, so all of us would have to come together and make this a whole big piece. And,
Yes.
and I think that, like I said, when I read some of what was in Kiwanis court situation and what they presented to the judge, I thought it sounded pretty good, but I guess the judge, so I don't know how much detail you got to get for this particular judge, and everybody needs to read that in order to come for a plan, because we can actually take some of the stuff that they have. And the issue I had, and I discussed with Fred, was I could not understand why we can't get the same, why they can't represent us, give us the space.
That's right.
The same way that they're helping Community Board 6 and 9. Now and to me, that would have been neutral, but they're not involved in that. They don't want anything to do with that. And I don't understand that.
Well, that's primarily because we're talking about community boards that have probably a lot more political power and are majority white. I mean, that's really what it comes down to. Like, they don't want to give you the resources because of the makeup of this community. And that happens all across the city. It's not just us. But what Gowanus is getting is much better than what we're getting, and we should be demanding the same.
And I'm saying if we are community board, I don't see why, and if everybody's talking about it being neutral, for the Department of City Planning should assist us the same way, because they're gonna have staff on board and all this, so why can't we? And I have an issue with that. That's all I'm saying.
I agree
And it needs to
completely.
be looked at, because I don't feel like we should be doing what, now we gotta go find the place, we gotta work with it. Well, how come they don't have to do it?
Well, one of the,
Well, to be clear, you don't have to do it either. I mean, if this is
No, but
something
we
that
wanna
you are,
move, we wanna move forward one way or the other though.
well, what I'm saying is, and it's whatever the committee and the board ultimately is comfortable with in terms of, if we say it's more hassle in terms of we just want to do it with our own and they get for people, that's fine. That's something we can weigh. If we say that, you know what, I'm not saying necessarily something that's out of the scope of why don't we can't make that request. In terms of we agree on 8 parts of that, and let's see if we can contact city plan and see if they'll take care of that last piece. Maybe perhaps it's something they reconsider. But ultimately, remember, it's again about if this plan is something that is acceptable to the ULURP, it helps us to accomplish the goal in terms of having a hearing that does everything so that we can get the information and the testimony to the board to make a decision at the end of the day in a time, within that time framework that we have. I would say don't settle for the no. It's like there's nothing that says we can't ask for it. Okay, well, listen, DCP can reconsider. But let's kind of figure out what the framework is, the pathway that gets us to where we're going to go. If you don't see a pathway, then this is not even a conversation.
Could I ask Richard a question real quick? Richard, I just have a question about, do you think that the discrepancy might be because the Gowanus rezoning is a city-initiated rezoning and this is a developer-initiated rezoning? Is that part of the reason that they're not giving us the same?
That's what I wanted to say. So obviously, if one applicant, but they're the city of New York, can pay for logistics, it's a fair question whether applicants can pay for logistics. The conflict of interest board is available. I suggest you may want to consider reaching out to them to get their determination in terms of whether the applicant paying, whether it presents any improprieties, because one could argue city planning doing what they're doing is trying to influence an outcome or not. You never know.
Thank you.
I think that that's a really great idea, Richard. Here I'm complimenting you.
May 11th, 2021.
You know what I'm saying? Because that was really, it's an old joke, folks, if people don't know, it's an old joke. But I think that's one of the things that there are 2 things forward that we probably can discuss. One is possibly having another meeting where we can actually start to create a plan and reach out to different organizations and see who can host it, nonprofits who would be a little bit more neutral. And 2, definitely reach out to the conflict of interest board and find out if they believe that a developer who's requesting, approval of a plan should be involved in, conducting that hearing, at the community board. And I think that those 2, and maybe you guys can ask the conflict of interest board to expedite the response, letting them know, or maybe I can even ask the court to figure out a way, maybe she can expedite the response to that.
Yeah, but I don't know, at least we keep saying that they are gonna conduct the meeting. That's not what's on the table. They're not conducting the meeting. They are working in conjunction with.
Yeah, but even that.
Yeah, but it would have to be chaired from, it would be chaired from the committee chair of the meeting. I mean, it's not gonna be like they don't chair the meeting and we would chair the meeting.
Yes, but Pat, they are choosing the location. They are choosing the staff. They are choosing the nonprofit. They're choosing the outreach. They're basically running the meeting. They said that they're facilitating. That's the words that they use. That's the document that's in front of us. They said that they are the facilitator. That would be the wording that the conflict of interest board would look at and say, can this private developer facilitate an in-person hearing via an application that they are asking that particular entity to approve? Would that be a conflict of interest?
Okay, I don't want to beat a dead horse, but I want to move on. But let me just say something. We don't have to agree to that. It has to be an agreement. I keep saying.
I think Warren had a question.
I'm sorry, Warren.
No, I don't have a question. I have a statement.
Okay,
Basically, I agree with Pat. This is our hearing. From my reading of the documents, but they're saying that, and I'm not saying I'm for or against it, and most of you know my position on this. Basically, what they're saying is that they will facilitate the in-person. So that has to be clear to everyone. They are not running the meeting. The community board is running the meeting, and we now have a Zoom for 500 people. And I'm predicting that the majority of people will be on Zoom. As for all the other questions that everybody's raising, I happen to agree with them, but don't misinform people what's going on. The community board will run the meeting. I'm assuming there'll be a higher percentage on Zoom, and we have to find an acceptable terms for the public hearing. That's the beginning and the end. Is this an acceptable thing? That's something for the committee to decide. Thank you.
okay.
So piggybacking on what Warren said, I've been thinking, as we're looking at spaces or contemplating the type of space, how many people are we anticipating? What size space should we be looking for? How many chairs should the building be able to accommodate?
Can we address the
a
question
park,
of
wherever?
why it has to be an indoor meeting? I'm really not comfortable with the idea of an indoor meeting that potentially has a large number of participants. I really don't
agree.
think that's a good idea.
And mostly elderly participants that don't have access to computers. It's a really, really bad precedent.
There is nothing stopping the community board from asking for an outdoor space. There's nothing. We could look at our outdoor spaces.
I mean, the one outdoor space that I can think of that has an amphitheater is the band shell in Prospect Park. There's a sound system there. That would be my first thought.
But that's
Suki.
really all the way over in Park Slope.
Yeah,
Yeah,
And it would be
Suki,
very
that's not
difficult
part of
for
our
us-
community board.
And it
that
would be
takes you so
difficult.
far out where it's kind of almost counterproductive. You're so far out, it's harder to get there. Especially for seniors and the elderly and people we're talking
Yes.
about, we're trying to actually.
You could even do it at Ronald McNair Park with a sound system. As long as you have a sound
Exactly.
system, there's nothing stopping, there's plenty of room there for people to spread out. And even if you had 50 or 100 people, there'd be more than enough room. They just have to be willing to do it. They do jazz out there, like on like all the time. Like they have a full sound system there. So I don't see why we couldn't do it there. That's within Community Board 9 and would be,
You gotta be prepared for rain. That's the problem.
Well, you could all, in the Gowanus case, they have a rain date. You could always do a rain date.
Okay, I'm gonna move on. We're going a little past time, but I do want to, I've heard some, so far, it's been a good discussion here. And it seems that, and this is where hopefully we have to pass a motion on whether we're gonna be inside or outside, because I think that's the whole a whole new situation here. I didn't know that people didn't want to be inside. You want to be outside.
Yeah.
So that we need to, I guess we need to have a motion on whether we're going to be inside or outside, because that's taking us forward as to where we're going to be. But before we get onto that, there was somebody, I think, from a community. I don't know who it was that wanted to speak.
Julia,
but I think she,
Where'd Julia go?
I don't
I'm
know.
bringing community in now. Where did she go?
I don't know.
she had to leave, maybe.
Okay, she had to leave. Okay, so can somebody kind of give me a where we're at now in terms of what our position may and may not be that we're voting on, and the outdoor space. I don't know if y'all agree or disagree with the outdoor space. I'm not going to get into whether it should be in a church or not in a church or this way, that way, but I do think there are some issues, and I think that I think the judge needs to be clear, because if what you read in terms of what the judge said in terms of the memorandum that she wrote or whatever it is that she wrote in terms of the developers, where she is saying that, you know, work with the developers and this and that. So we need some clarity there. And again, I don't see anything wrong with us asking the Department of City Planning, who's supposed to be a neutral. Well, I mean, we need to get some of these how you say helping hand to help us out too. It just shouldn't be Community Board 6 and 9, and I have an issue with that. And I think I asked Fred, but he couldn't answer that because city planning has nothing to do with it. They say that's what's said. But the lawsuit, Alicia, I believe, is against city planning, not Community Board 9. So we, like I said, we keep getting things secondhand. So let's take a
Excuse me, Pat. it's
yes,
Warren.
Warren.
Yeah, I think we're premature on voting whether or not we want an outside or inside space.
Okay.
The first thing the committee has to vote on is, number one, do we want to work with the developer on the proposal that he or her submitted? And the second part is, depending on the outcome of that, is, you know, the planning of the actual meeting, indoor, outdoor, whatever, it is, you know, that's just rudimentary. So I think we're overstepping our bounds here. We should first decide whether or not how we want to proceed with the developer and then talk about the details.
Well, and prior to that, though,
if I could
prior to that, if we could follow through on the idea of checking with the conflict of interest board, I think that would come first before saying what we want to say about the plan itself, because we want to know if it's even correct for this to move forward as it is. So I don't think we could even like have the conversation about what the plan is until we know that it's you know, it's okay for us to proceed with that. And I think that's, for me, that would be really, really important. If the conflict of interest board comes back with like, yes, it's fine, these are the parameters that you should do it in, then we have a blueprint for doing it. I don't think anybody here is like, clearly we're not just trying to like obstruct or anything like that. These are valid concerns, I think, that people have. And so checking in with the conflict of interest board and seeing if the judge can expedite that, and we can start there. I mean, I think before that, doing anything before that would also be premature, like Warren is saying.
Okay. Let me take that piece. COIB tends to be pretty quick with their responses in terms of they come back. I can take that on behalf of the board in terms of asking that question. So I'll make sure we make the inquiry to COIB, and we'll get back in terms of if they're weighing in terms of it's permissible, not permissible.
But Fred, just because it's really important, because I'm dealing with the court and I'm dealing with attorneys. And so it would really be important that the ULURP has made a determination that they want to first sit there and find out about the conflict of interest, that a motion be put into the floor, that it be passed, and that way I could take it to the judge and say, Your Honor, there was a motion put on the floor at the ULURP. They said that they are concerned about the conflict of interest. They would like to first do the inquiry and then, you know, and then move forward. And again, ask her to expedite that, which might be a little bit even more forceful than a community board.
Alicia, I agree with you. I make a motion that we table this until the community board gets information from the conflict of interest board as to whether our proceeding is okay or not okay.
I would like to. Well, can we? Is there discussion on the motion or?
Well,
Yeah,
hold on. As a point of order,
Motion on the floor.
Right, point of order. It's not really a motion. You don't motion the table unless there's a motion on the floor.
Wait a minute, you're getting all mixed up. There's a motion to table the motion on the floor.
There is no
There's no
motion.
motion on the floor.
Oh.
So you can't table something that's not made.
I thought it was a motion. Oh, it's a discussion here. Okay. Okay. Again, and Alicia, you're going to court, we're not.
Right.
I also think there needs to be some clarity from the judge.
Mm-hmm.
Okay? Because when she is saying work out a plan with the developer, then that's what we need to do. And they have the right to pick the place.
I don't. I don't believe that they have the right to pick the place. I think everything that they presented is negotiable. I believe if the community board is not comfortable with the place, you can say that. You could say, you know, we are not comfortable with that. We feel that it's a conflict of interest for us to have something at a church that has already openly stated that they support the development project. I don't think that the judge would find that unusual, nor would the judge feel like you're doing something improper, because you're trying to find a neutral place, you
Well,
know, and so you could, you know, I don't think it's so far-fetched, Pat.
Well,
Right,
all
but
I'm saying is,
go back to my
all I'm saying is that
statement.
Suki had a problem and it made a lot of sense. Suki did not want to be or have the people to be inside. And then somebody talked about senior citizens. So I'm just saying, okay, leave me on so we can close out. Tell me what we're doing.
If I could offer this as well,
Yeah.
I think part of what might be helpful is there's just a lot of information you don't have, or we don't have, I should say. And some of that is really the negotiation piece that you have with the developer in the room. In terms of, we don't want that, can you get another room? Sure, or no, we can't. Because that'll tell you what the answers are at the end in terms of what you can live with. And if there's things we can't come to agreement in, that's the answer. Where the board, you know, the board has not voted to adopt the protocols, or we've adopted these protocols, and that can go forward. So perhaps it's better to say that, you know, and not to get into everybody's schedule, but perhaps it's better to have a meeting where the committee can discuss with the developer there invited, along with, you know, district office representation in terms of saying what they can support as well, because that way you'll come out with the answers at the end of that meeting, and you'll know what you can do and what you can't.
Right, and I also, if we're doing that, I don't know if the committee members have a copy of what the judge wrote in terms of the Corona's project, where she has her disposition on what she wants and not what they need to. We read that because there's a lot of things that we can adopt real quick and work it out. That's what I'm saying. It's things from 1 to 9 that we can actually say or correct or put in order. It's going to be easier than starting from scratch. That's my point. And I think if the committee members have a copy of that, they can read that, and then we can come up with something in conjunction with the developers.
So can I just make a suggestion for a motion? And of course, I'm not a committee member, so I know I cannot put a motion on the floor, but this is a suggestion. Just
Well, there's already a motion on the floor, so I
yeah,
think
but
we should vote on that.
Hold on a minute, Lisa. What somebody told me that I was wrong. Was no motion on the floor.
No, I disagree with what was said. There's a motion on the floor to table this until we get more information.
Right. The point of order was there is no motion on the floor. You can't table something that's not on the floor. If you want to refer for information or make a motion to get additional information, that you can do. But, you know, you can't move to table something. That's the only point.
Y'all trying to mix me up real bad. Okay.
So
I appreciate that. So the motion on the floor is we table this motion until we receive information.
Doing it
from the
again, Warren.
conflict-
You're doing it again, Warren.
What? What am I doing?
Just move to seek
You're
additional
tabling a
information
motion
from the
that doesn't
developer.
exist.
you can't table a motion that does not exist. Okay.
No, I'm making a motion. So the motion is to table this until we get more information from the Conflict of Interest Board and more information from the developer.
Table the discussion, correct?
Table the discussion. Mhm.
So one of the things, however, I think would be important is it possible that you can create another motion where you would be willing to meet, have an open meeting where you would discuss the creation of a plan. I mean, I think Pat has been very concerned about possibly looking at the Gowanus and formulating some of the steps that the Gowanus have. So why not have another meeting? I know puts more pressure on you guys to have another meeting, which has to be open, obviously, and invite the developers. We look at the Gowanus plan, and then people, you know, kind of come up with a plan that could work for the community, work for CB9.
I agree 100%.
And also at the same time, looking at that conflict of interest. So
I
that way,
agree.
That's first. That gotta be first. We can't negotiate around that.
Right.
Now, I don't know if the committee agrees or not agree, but that gotta be first.
No, I agree with the whole thing.
I didn't really
But I
make
still
a-
hold that out. I can contact COIB to find out if there is any conflict, any perceived conflicts with that. So that I can do right now,
I just,
and the committee
yeah.
can continue in terms of any of the conversations.
Now, I just want to know, would the committee, if we had to come back together, because we're not in court or anything, we got to come back to together and work out something with developer.
Could I ask a question real quick? What would be the either benefit or not benefit of stating affirmatively that we don't agree with what's been presented? Because I don't think that we do. I mean, I think that's obvious, that we don't agree with what's been presented, but we're trying to work with, I want to know what the court would see as.
Well, it's not we, let's say you don't agree. It's not a we, it's you don't agree with what was submitted.
Oh, I mean, I'm pretty sure that we would
The
get.
reason I say it's you, is because we don't have a plan yet, so it ain't no we.
No, I'm saying the plan that's been presented.
There's no plan.
Because I requested before this meeting started to have a vote on whether this is going to be what we're going to follow. So that was essentially a motion. I didn't actually make it as a motion, so I guess I'm stuck on that. But
at least you're saying it's true. We don't have a plan. When you do a plan, it has to be all of us that's involved in the plan. It has to be the developer, the community board.
Right, but they're asking for a very specific.
Plan.
Right, but they're asking specifically for us to agree to their plan, and I think that's. I mean, are we just going to not respond? Is that what we're doing?
Well,
No,
Pat, if I
Esteban
can-
That's not a
if I can-
plan.
I thought that Warren had a motion on the floor that we
Correct.
need clarification from the Conflict of Interest Board before we continue working on any type of plan.
Right, and I'm willing to amend that to Lisa's suggestion that we reach out to the developer as well as the community and the community board to develop a plan.
I can agree to that. Yeah.
Well, I think the
Okay.
conflict of interest first has to clear. So I think you might want to have two motions.
No, you're
One,
correct, Alicia. First, we'll get the conflict of interest, and if there's no conflict of interest, we'll proceed on the rest of the motion.
okay.
Is that agreeable?
Well, can you put the motion on the floor if we got one? Because right now, I'm gonna be very honest, I am so confused. I don't know what's on the floor, off the floor.
Right,
So
and how
do we have a
think we-
motion on the floor? And what is it?
Yes, the motion on the floor, since I'm doing it again, and I'm completely confused as a secretary, but the motion on the floor is to table, okay, the decision on whether or not to cooperate with the developer until number one, we get an opinion from the conflict of interest. And number two, if that's positive, obviously if it's negative, we don't go further. But if it's positive, that we develop a plan with the community, the developer, and CB9 to hold a public hearing.
That makes sense to me. But
Okay, I
Second.
heard you.
I second.
Oh, do we have a quorum here? Because I don't,
Yes, we do.
gotta make sure. Who are the people?
Okay, let me get back to my pad. Hold on. All right. So any discussion?
Well, yeah, just one point I just want to throw out here is this. Bear in mind, as you make this decision, there is also a clock running in terms of our year ends June 23rd. I want to be very clear about this. Our year technically runs out June 23rd. So I want you to be very cognizant. If you need more time, if you want to deliberate, that's fine. But the longer this takes, the less likely that even if you wanted to do this, this happens this year. So I just think that it's important that the committee understands that as well. So delaying a decision might be making a decision where you're not doing it. All right.
I-
I just want to make that information.
But I also want to also piggyback on that, Fred, because the city charter revision of 2019 just extended community boards hearings when it does move into the summertime. So there's an additional 30 days that's added on to the clock. So, we are working with that as well. So
Right.
That
Well,
may
the issue is
be
even
to argue.
with the extension of the clock, the point is, the board goes into hiatus when we go into the summer.
Right.
Then obviously there's questions about how many days are left on the clock in terms of, I've seen different numbers. We have 19 days left, which makes it tough to do a lot of stuff. If you add 30 days or if they restore clock time, there's just going to be a whole lot of parameters that really kind of make it difficult.
Is the
So I just
ULURP
wanna be
clock
very
paused
clear.
right now?
Yes, the
ULURP
ULURP
clock is paused.
is paused.
ULURP
Yes.
is paused.
Okay.
If we were to do, if we were
Can we
to do
have a
nothing,
vote on the question before we forget about the motion?
can I just,
We're discussing.
ask a quick question on that?
Yes.
If we were to do nothing and just walk away right now, and then the court would have nothing to go on, how long is that clock paused? In other words,
I don't know. I
That
think
the
what may end up
judge-
happening is there'll be a decision on whether, and this is just me, I think this goes back to the original question was whether virtual meetings were valid, whether you need to have an outdoor component.
Right, can I
So the
answer
judge has asked
Esteban's
the board-
question?
Hold on, yeah, if I could just finish the point, then absolutely jump in. So the point is, I think the judge has gotten trying to get the parties to actually have a conversation to see if we can come up with some kind of a hybrid where you can actually have that in-person portion. If we are not able to come to an agreement, I believe, for what all the 2 cents it's worth, that this reverts back to the original question in terms of, do we go forward with a virtual meeting, or is virtual meetings illegal? And at that point, that'll be a whole other conversation that'll be had.
But
But
No.
what I wanted for this board to consider is whether we can have a process. If you see a pathway for us to have a viable process where people can come and give testimony and weigh in on this, so that way the board can make a decision, again, with that time factor in a timely manner where we can give that and submit, okay. If you don't see that, I wouldn't worry about that piece of it. Just do, the best you can with regards to that. I'm sorry, Warren, I think I cut you off a minute.
Yes.
Well, I'm sorry, I'm jumping in Pat's role.
No, I think I cut you off.
Can we vote on the motion now?
No, just hold on a second. To answer Esteban's question is that if the board doesn't submit a recommendation, it moves automatically to the borough president. And according to my sources, that the board can submit a recommendation at any time. My opinion on that is that we need to get a recommendation in. But if we do nothing, Esteban, it just moves to the next level. We are completely advising.
gotcha. But we could presumably submit something, and then 2 months into the process from that, we could, once the board is back in session and if something changes, we could submit again, correct?
Correct.
I mean, it wouldn't affect the borough president's decision necessarily, but
Yes.
but it could, it still goes,
But
it still
but
be in the documentation,
As long
that's
as
not-
long as
no,
we
it's
have
not-
the
that's not
agreement of
true.
the
That's
board.
not true.
No, it is true, Alicia. That's the process.
No, the borough
Yeah.
president's recommendation is based upon the community board's recommendation. So he
I
refers
disagree.
back to the community board's recommendations when he makes his recommendations. There's no point in the ULURP process where you could, if you passed your time, that you can now resubmit or
Of
submit
course you
later.
can.
There's nothing
Of course
in,
you
there's
can.
nothing in
So
the
you're
city
wrong.
Okay,
And
we
not
don't
to
wanna,
argue that-
have an
not to argue
argument
that.
about that.
Okay,
Yeah, I
so
just
right,
want to say one thing.
Okay,
We
listen to
need to
me.
get our recommendation in on time. That's
Okay.
all.
Well, first of all, Richard is up there. If he wanted to, if he disagreed with us, he could have stated it. But my point is that we got a motion on the floor. And my point is that I would not like for us not to have any input at all. That would not, but you have to understand that we're not representing ourselves. We're representing a whole community. So I would hate to say that, oh, we just gonna let it go bypass it. We don't have no voice.
So that's why I'm asking. That's why I'm asking the question, because there are a lot of people that I answer to personally that are going to be paying attention to this. So Richard, could you clarify it?
Yeah,
maybe a little
so
bit?
whenever the community board's clock runs out, whether you make the decision or not, right? Because you can make a decision, sit on your decision, your clock keeps ticking, right? Or you could submit right away and end your clock. But whenever your clock runs out, borough president clock starts, right? However, I always encourage community boards to submit, even if their clock is over. In fact, Community Board 8 Their clock ended last night. They're voting on May 13th, right? We're not ignoring that. Nobody's going to ignore it. There's no charter police out there. The only time that matters is when it's a triple no required to get the city council to act. The council acts on this item, right? So no worries. I've had boards submit close to day 30 on my clock. The only problem for me is the later the board makes a recommendation on my clock, it's harder to make a decision based on the board. You know, sometimes at a certain point, you got to make a decision. If the board's going to decide day 25, very hard for us to write a report in 5 days, get it edited and whatever, right? So but to me, no matter what your logistics are, obviously you'd like to influence the borough president, you'd like to influence the city planning commission, but the most important influences at the end is at the city council. So if life got in the way and you only submit it before the city council, it's still helpful to the process. I just don't benefit from it.
Well, I think that we should vote on the motion and hopefully, you know, we could run this clock down if people are ready to come back in when it's not a scheduled meeting. I mean, we could, like Alicia said, we could all sit and figure out something or write something. That's not a big deal. If the committee's willing to, and we can do this before June. It don't take all day, because if you read what I'm saying, we all put it together, we can move on. But we gotta have those three entities in there. So now the motion that I forgot, it was so long. Are we voting on that?
Yes,
Because Fred, you're the first one. You're gonna get back to us right away as to whatever's gonna happen. Alicia's going to court tomorrow. So,
right. So the motion is to table a decision on whether or not we accept the developer's suggestions until we get an opinion from the Conflict of Interest Board, as well as input from the community, as well as CB9.
That was not the motion.
What was?
The
Well,
motion,
tell me what it was, Alicia.
okay, the motion was that you will be tabling the discussion
Uh-huh,
of the plan, of the developer's plan, until the
correct.
conflict of interest makes a determination whether or not there is a conflict. If it is positive, if it is negative, that there is no conflict of interest, then the community board would then proceed to engaging in the development of a plan with the developers, CB9, and the community.
And the community. Thank you. That's exactly it. Okay, and we had a second, so should we vote?
Yes, but
Yes.
somebody has to record this correctly. You're the secretary.
No, I just wrote it
but let me
down
ask you a question.
verbally.
Isn't this being recorded?
Yes,
Of
but-
course.
But I'm going
Alicia,
to court
Alicia,
tomorrow. I'm going
Alicia,
to
have a
court
little
tomorrow.
faith. That's the exact motion. I agree with you.
Okay.
So can we take a vote?
Yes.
So I'll do the roll call. Okay, everybody, any other discussion? Okay, Suki,
Yes.
okay, Nicola,
Yes.
John Cravier,
Graver, yes.
thank you. Esteban,
Yes.
okay, Nolan is not here. Pat,
Yes.
okay, Tom Thomas is not here. Ricardo de Libera, absent. Erwin Brown, absent. Okay, it's unanimous. The motion passes.
Can I just ask one more motion for you guys? And that is to request the draft restrictive declaration. That you pass a motion requesting that the developer must produce the draft restrictive declaration.
I second that.
And all other outstanding documents that have been requested.
Well, why don't we start small and get the important document?
Okay.
Let's do a follow-up on the first letter we have, because there are certain things that they don't really have to, if they don't want to. So let's just do that.
Well,
So
the restrictive
I yield to
declaration,
the chair.
we asked for that in writing, we can ask for that again.
well, but if you have a motion, I could bring the motion to the judge.
I'll make the motion that I would like to make a motion that we request from the developer the restrictive declaration, draft of the restrictive declaration as we requested already once. Is there a second?
Is there a second?
I'll second.
I second.
Can we do all in favor, or do we have to do individual?
Do all in favor.
All in favor?
Aye.
Any against? Any abstentions? It's passed unanimously.
Thank you.
Okay.
So I will
My
take
pleasure.
I would take these two motions to the judge tomorrow at 2 p.m. when our hearing, and we'll see what she says.
Okay.
Okay, so we're gonna
long meeting.
I know, listen, I normally like to get out early, but listen, this is real important.
Yeah, it was
So-
a good meeting.
So
Good
listen,
meeting.
but I just wanted to say before we close out that there are two members. I didn't get an opportunity to get to these. There are two members that have attendance problems, and they're never at our meetings. And I just want them. Well, I already put in for them to be removed due to poor attendance.
Is that
And the
Richard
first-
and Irwin?
First one is Erin Brown, and she is a community board member. I think we've seen her all but once. And I wanted for the records that she really should be removed. She might have been here one time, 2 times maybe. And I think we can research, we can actually research her, but she's definitely been missing. The second person is a community resident. His name is Richard, and how you pronounce his last name? It's spelled Villabrea.
Villabera, and you know
Right.
I'm an expert on enunciators.
Well, that person needs to be also removed. So,
Pat, for that, just send me an email requesting that they be removed from attendance with whatever meeting, if you have it, whatever meetings they missed. And we can
yes,
just
but
fix
I
it.
just wanted the board to, to know exactly what I was going to do, because I think attendance is important. And I don't think it's fair for everybody else to have to come and these people just show up to vote. So I just wanted to bring it, and I will send you I'll send you a memo, but I just wanted the committee to recognize these two people. So when they come
I
at the
just want
end, when they come at the end and we voting, we're not gonna take their vote because they ain't here.
Pat, I just want to make a statement that I agree that by having less people who don't participate on the board makes our quorum requirement and the thoughts of the existing members more important. So thank you.
Okay, so
Agreed.
can I get a motion to dismiss?
So
Motion to
can I
dismiss.
make a quick comment?
I'm sorry, you want to say
Um,
something before we dismiss?
Can I make a quick comment regarding the restrictive deck? So obviously, I don't see it the same way it's been talked about earlier, but if you want to see an actual restrictive deck, because we review special permits, not very often, but the last one I reviewed for the borough president is Marcus Garvey Village. And that that restrictive deck exists. It gets filed with the property, right? So if somebody wanted to make a little bit of effort to pull that restrictive deck, you would have an example of language. And the key thing in the language is referring to the drawings. And you do have the drawings and the special permit only applies to the developer controlled property, not to the larger rezoning area. So those are just some key things I wanted to point out. And if you get a copy of the special permit for the L&M equity site at Marcus Garvey, I'm happy to discuss it with anybody for technical assistance.
Is that a large scale general development site as well?
Yeah.
A large scale
Um,
manufacturing industrial development site?
And by the way, the manufacturing only means a manufacturing district. It's not, the manufacturing district doesn't apply here. So it's, in this
But it
case,
is,
it's
that's
just
what they're
a,
asking for.
yeah, no, they're not. No,
Asking
if you
for
look
that
carefully,
designation, so it
no,
does
if you look
apply here.
carefully- if you look carefully, and I'm happy to
So what
email
I
you.
read, I don't believe, I don't believe what I read.
Okay,
You don't have to email
I'm
me
happy
anything,
to-
Barack, I could read.
Okay,
It says
fine.
large scale
Fine.
manufacturing industrial development. Okay, but is
Okay,
is that
that's
restricted
not
declaration
exactly-
that you're referring to?
well, let me say something. I like one at a
There-
time. I
there
can't get
goes the
three
truth.
people at one time. So
I
I
mean-
think that we needed to dismiss because it's 8:53. And like I said, I hope that with the committee, we may have to come back together. We might just only have a couple of days notice to come back together when they go to court and all this. So I hope that we will all be available or try to make ourselves available to at least do a plan.
Yeah,
And I would like to close out the meeting, but I also want to say I definitely want community board, community to have some type of input. I don't want it to go forward. That's just my individual opinion without having any input from the board or the community. That's it. So I get a motion to dismiss or something and.
I move that we dismiss.
I second.
Okay, so it's now 8:54.
wait, all in favor?
Aye,
Aye.
All right, okay.
Bye.
thank you.
Everyone.
See y'all later.
All right, thank you, Pat.
Thank you,
Bye,
Pat.
bye.